Welcome to our second podcast exploring human rights in BC, presented by VIHRC, the Vancouver Island Human Rights Coalition. VIHRC is a community based, nonprofit agency located on the traditional territory of the Lekwungen peoples, known as Victoria, BC. We help individuals and organizations uphold and promote human rights through advocacy, support, and human rights education. If you feel you have been unfairly treated or discriminated against for whatever reason, or would like to contact one of our advocates, please send us an email at contactvihrc@gmail.com or call 250 382 3012. You can also find more information on our website, vihrc.com, or follow us on Facebook or Twitter. In this second episode, we will be diving into more specific topic of discrimination based on race from the perspective of the BC Human Rights Code. Our discussion in this episode will build on the issues we talked about in our first episode, so we would recommend listening to that one first if you haven't already. In this episode, we will discuss the 4 different protected characteristics which capture the broader concept of race and explore the details of proving a case of race-based discrimination before the BC Human Rights Tribunal. One brief disclaimer: this podcast does not contain legal advice. It contains general discussion of certain legal and related issues only. If you require legal advice, please consult with a lawyer. Our first question is, how is race protected under the code? In our last episode, we mentioned that 4 different characteristics related to race are protected under the code. They are race, color, ancestry, and place of origin. It may seem strange to have 4 different protected characteristics which are also closely related. Why not just have one category of race which includes all of these characteristics? The purpose of explicitly naming 4 different characteristics is to capture the complicated and multifaceted thing that race is, and the different ways it might factor into an act of discrimination. It allows complainants to prove discrimination that might not be captured neatly by the concept of race, even though discrimination along racialized lines is clearly at issue. Let's consider some examples.
In a case from 1999, a group of doctors complained that the BC College of Physicians and Surgeons discriminated against them for their race, ancestry, color, and place of origin. The doctors had received their training from Italy, Romania, Russia, and the Philippines before immigrating to British Columbia. At the time, the college required graduates of non-BC medical schools to complete extra residency training before becoming licensed doctors in BC. The college named 2 categories of non-BC graduates. Category 1 included graduates of medical schools in Canada, the United States, Great Britain, and Commonwealth countries, while Category 2 was for graduates of medical schools anywhere else in the world. The college required Category 2 graduates to complete 2 years of training, while Category 1 doctors only had to complete 1 year. Further, it was much more difficult for Category 2 graduates to get placed into the required training programs than it was for Category 1 graduates. If the complainants could only claim discrimination on the ground of race, they would not have been able to prove their case of discrimination. The tribunal only found the complainants were successful on the place of origin characteristic. However, the Category 1, Category 2 distinction effectively followed historical lines of marginalization by favoring graduates in Commonwealth countries which benefited from centuries of racialized oppression. The effect of the distinction was to further privilege people from countries where the majority of the population is white. However, this effect is not captured immediately just by the concept of race, because the distinction was made on the basis of where people had graduated, rather than any explicitly race-based characteristic. The protected category of place of origin, however, still showed that discrimination had taken place in a way that has racial implications because of the history of colonization. This would not have been captured by a single protected category of race.
The 4 different characteristics also allow a complainant to establish a case of discrimination, which occurs not because of one particular category like skin color, but because the different categories combine and intersect to form someone's identity. The racialized discrimination can only be understood when viewing the different protected characteristics together. A good example is a case related to discrimination that occurred while building the Canada Line. The complainants were a group of men from Costa Rica, Colombia, and Ecuador. They each had different skin colors, different ancestries, and similar but unidentical racial identities. However, the tribunal found that all four grounds of racial discrimination, race, color, ancestry, and place of origin, were engaged by the complaint. The complainants were hired to work on the tunnel for constructing the Canada Line in Vancouver, BC. However, the construction company who hired them paid them lower salaries, put them up in worse hotels, and provided worse complimentary meal options compared to a group of European men hired by the company to do the same work. While the complainants did not share any individual protected characteristic very strongly, they did share all of the protected characteristics related to race more broadly. The complainants all came from a defined geographic area of Central and South America. They all spoke Spanish and had a shared set of cultural practices and preferences. They all had relatively dark skin compared to their European counterparts. Collectively, these clearly showed a distinct group identity compared to the European workers. The tribunal found that these characteristics work together to form the basis of the complainant group's identity, and unfortunately also the discrimination against them. The tribunal found the real concern in human rights law is not race, color, or genetics, but the discrimination itself. In this case, how the employer viewed the complainants as a distinct and racialized group of people and treated them poorly because of it. This is the power and purpose of having several different characteristics related to race protected under the code. It allows individuals facing discrimination to cast a wide net and capture the complex and nuanced ways their unique identities shape their lives. It also helps the code recognize and respond to the intersections race has with different aspects of identity. In the next episode, we'll talk more about this idea of intersectionality and how the tribunal treats cases where race based discrimination intersects with other kinds of discrimination on the grounds of disability, sex, or gender identity. For now, we'll turn to the details of proving a claim of race based discrimination.
Recall that in order to prove a case of discrimination, the complainant must show three things. First, they have one or more of the protected characteristics, or they were perceived to have those characteristics by the respondent. Second, they experienced an adverse effect. And third, the protected characteristic was a factor in the action which caused the adverse effect. We talked last episode about how difficult it can be to prove the last point, that the protected characteristic was a factor in causing the adverse effect. This can be especially difficult to prove for cases of racial discrimination because racism most often affects people's decisions subconsciously. This has been called the insidious nature of racism. Even the respondent may be unaware that they discriminated against someone because of their race if that person believes they are not being racist. This happens in cases of racial discrimination in particular because racial biases are so often subconscious. Of course, the same issue may arise for other protected characteristics. For this reason, the complainant may not need to show direct proof of discrimination, such as someone using a racial slur, at the third step of the legal test to prove discrimination at the tribunal. Rather, the complainant needs to show that there is some evidence that supports an inference of discrimination. The tribunal will infer discrimination where, based on the evidence presented, discriminatory behavior seems more probable than other inferences or hypotheses. In other words, there must be evidence that proves the necessary link between an individual's race and the specific adverse treatment. If there's evidence to support an inference that there is a link between the adverse treatment and the complainant's race or any other protected grounds, the respondent still has an opportunity to provide a reasonable explanation for their conduct. If the reason for the conduct is reasonable and non-discriminatory, then the tribunal will not find discrimination occurred.
A good example of when the tribunal will find an inference of racial discrimination comes from 2005, when an Indigenous woman, Gladys Raddick, complained against mall security services for discriminating against her on the basis of her race, color, ancestry, and physical disability. Ms. Raddick was followed and harassed by mall security while trying to have coffee with a friend. The tribunal took notice that Indigenous people face systemic discrimination and racial stereotypes that include assumptions of being drunk or otherwise intoxicated, and acknowledged Indigenous people face these stereotypes because of Canada's colonial history. The tribunal also discussed the insidious nature of racism, which made it difficult for Ms. Raddick to prove that racial discrimination was a factor causing the security guard's harassment. But because Ms. Raddick had established discrimination on its face by showing that she had a racialized Indigenous identity and that she was harassed, the burden of proof shifted onto the security services. They had to prove that the actions of their security guards were not racially motivated. They were unable to do this, and Ms. Raddick was successful in her complaint. Importantly, this inference of racial discrimination only reduces the burden of what the complainant must prove. The complainant must still show some facts that can support the inference of discrimination. Many complainants fail on the grounds that they can provide no evidence at all that supports a connection between the adverse effect and the discrimination.
An example of this comes from a 2018 case. In that case, the tribunal found that the facts of the case did not support an inference of racial discrimination. This decision involved a complaint by Ms. Batson-Dotton against the Provincial Health Services Authority for not hiring her on the basis that she was Black. She had applied for a job with the PHSA 3 times, and each time was unsuccessful and the positions were offered to white candidates. While Ms. Batson-Dotton had established that she has one of the protected characteristics and that she experienced an adverse effect, she was unable to prove that the protected characteristic was a factor in the action which caused the adverse effect. The tribunal noted they cannot assign liability for racial discrimination in the absence of sufficient evidence which proves the necessary link between an individual's race and specific adverse treatment. Another case, which deals with the third step of the case for racial discrimination, involved an Indigenous mother and son who were discriminated against by the police. The tribunal reaffirmed the difficulties of proving racial discrimination while also taking note of the particular issues relating to indigeneity and the colonial structure of law and power. This case establishes that the appropriate standard for inferring racial discrimination is where the evidence presented makes such an inference more probable than other possible inferences or hypotheses. Thank you for listening. In our next episode, we'll be looking more at the concept of intersectionality, which we mentioned today. We'll also explore how racial identities can combine with other aspects of identity, such as disability and/or sex, and we'll understand how the tribunal treats discrimination based on these combined grounds differently. We'll also examine a recent proposal to add a new protected characteristic to the code. This has been Lauren and Nico with the Vancouver Island Human Rights Coalition.